Ladies and gentlemen, good afternoon, and thank you. Welcome to this webinar on international commercial agency contracts. A bit of a mouthful. My name is Dave Mertens. I'm a partner at Schoops, and I'll be guiding you today through this, what I feel to be an extremely interesting subject. Of course, feel free to disagree after the session. But before we dive into this topic, perhaps a word from our sponsor, or at least my sponsor. For those who are not that familiar with our firm, or not fully informed about the recent developments and the growth our firm has gone through. Today, Schoops is 80 plus lawyers, currently 85, not 82, 26 staff with 2 offices, the main office still being in Antwerp, where I mostly work, as long as I don't work a home office, and also the quickly growing Brussels office, where we offer the same services, but also in French. As most of you probably know, we heavily invest in seminars, webinars, newsletters, so feel free to subscribe to our newsletters or the schedule for our webinars if you would like. Most of these webinars we do in either Dutch or French, but today, as you've probably heard, I've opted for English. Why? Not because I'm a native speaker, because I wanted to include a few of our clients who speak English and not Dutch or French. And also because this topic, the international agency contracts, well, for national agency contracts, I often see Dutch or French versions for local companies working with local representatives. But when you talk about an international contract across the border, especially larger companies, it's mostly English that I see. So that's why I've chosen English for the language of today, and why I've chosen to offer you a few clauses, model clauses that you may or may not want to use in English, so you can chuck it into your contract should you so feel inclined to do. But always, and that's a disclaimer, one of the disclaimers you'll hear today, use these clauses with care. They have to be made to fit what you want to realize with your principal or with your commercial agent, as the case may be. So this is our firm. These are our seminars. What we also do, what I would like to emphasize, is what we do as a firm. Our traditional strength lies with construction and real estate, including commercial lease, working for major general contractors, working for retailers, commercial lease. That's one of the strengths we have. Project developments also. Public law, also a large pillar of our firm, mostly doing with public procurement law on the one hand, PPS, and on the other hand, environmental energy zoning. Thirdly, social law, individual labor law, collective labor law, that's number 3. And lastly, but certainly not the least, business law. This is the group I work in. With, on the one hand, you have the corporate M&A structure. That's one half of the business law. And on the other hand, we have commercial law, where I work in, personally focusing more on commercial contracts, distributorship, commercial agency, franchising, market practices. This is what I do within our firm. Well, a picture of who we are, one of our latest events, when it was still allowed to have these sorts of events, you will find maybe I'm the one on the left top side, one of the very few people whose face you can't really distinguish, but next to Chantal, the woman in white. Can't see my face, not by my own design. Perhaps the photographer thought it wise to keep me hidden, but well, there you are. Never ask questions to which you don't want to hear the answer. But for those who would like to see who I am, here I am. This is my picture. And these are my contact details. Should you, after this presentation, have any questions on this topic or any other topic, feel free to give me a ring or send me an email. I'll try to answer any questions you may have as soon as possible. On that topic, this presentation here I will show you now. Every participant will receive a copy of the slideshow after the presentation. And again, if you have questions on this presentation or anything else, feel free to contact me. Anyway, it's more convenient to you. And now for the topic itself. That was just a brief introductory. What I want to talk about today is international commercial agency contracts, and this is the menu for this afternoon. the next hour, hour and a half. First things first, what do I mean with commercial agency? The concept, we'll talk about that a bit. Talking about commercial agency contracts in international context is almost impossible not to talk about commercial agency directive, which harmonizes the rules on commercial agency on the EU level. We'll see that, talk about the fact that this harmonization and full harmonization, there remain differences between the different member states. Some of these differences are quite, well, have a large financial, potentially large financial impact. So we'll discuss those differences in a bit more detail later on, but we'll talk about the directive also. Each member state, as sort of a spoiler alert, each member state have transposed this directive more or less, to my knowledge, more or less correctly in their national law, but they have dealt with this on different ways. We'll see, we'll talk about that later on. Number 3, the scope, mostly the scope of the commercial agency directive. I'll address that. Briefly, it's key issues. I will not be able to talk about everything, but I will talk about briefly rights and obligations under the agency contract that you may want to enter into. One of the conclusions there will be that you're quite free to put in your contract what you want. This also applies to remuneration. I know money isn't everything, but it's a lot. So you need to think about how you will remunerate your agent, or how as an agent you want to be remunerated. Again, a spoiler alert, a lot of freedom, contractual freedom on this level, with a number of some important exceptions we'll discuss later on. Most litigation, as long as the contract is working, as long as parties both enjoy the collaboration and make enough money, is not an issue. Most litigation obviously revolves around termination of the contract, when, for instance, the principal has decided that his brand has been sufficiently established in the market, that the goal that the agent was supposed to achieve has been achieved, and wants to perhaps replace this agent by a distributor or by an own affiliate. So when we talk about termination, these are the kinds of issues we'll be talking about. Termination by the agent because he wants to leave to a competitor, by the principal because he wants to replace the agent by another agent, or by another way of bringing his products to market, which is more cost efficient. And the compensation due, and that's the next topic, the compensation due in those circumstances. Obviously, termination is important, and this is why it's key to consider the termination, the end of your relationship, as in marriage, when you start your relationship. You need to think about what you will put in the contract to anticipate proactively on the hypothesis that something will go wrong, or that it will go extremely well, and that the principal deems that the agent is no longer necessary. We'll talk about that in a bit more detail later on. Also, and this comes into play most prominently after the end of at the end phase of the current contract, restrictive trade clauses, non-compete clauses, not necessary. I don't see it in every contract, but it's something you need to think about. Do I need a non-compete clause during the contract? Do I need one after the contract? What is valid? What is enforceable under the directive and under the different legislations that we know in the different member states? Very briefly, Del Credler, very briefly, and a bit more in detail, because in the international context, it's quite an important issue, international private law. Talking about jurisdiction, talking about applicable law, talking about arbitration, all those clauses that non-lawyers typically don't really care about, but are in this context potentially extremely important, as they, as you will see, determine how much an agent can or may not claim, and where this agent will be forced to claim. And of course, sometimes the choice of law clause, the choice of jurisdiction, determines or will deter the agent from claiming in the first place. So these are things that when drafting you do need to think about, although it's perhaps not always the most sexy topic when you're negotiating a contract and focusing on remuneration and the way forward and the clientele that you want to target and the market that you want to address. So this is the menu for today. These are things I would like to talk about today. But first things first, commercial agency. What do I mean when I say commercial agency? The concept is vague in the sense that you have a lot of freedom, but clear also in the meaning of the directive. Commercial agency, what does a commercial agent do? The commercial agent is a natural person or a legal entity, BV and NV, could be either way, whatever. And this entity, natural person, will negotiate the sale or purchase. Negotiate is an intermediary, is self-employed. Intermediary is a go-between between the principal and the end customer, whether this customer is a consumer or another company. Mostly, well, very often it's B2B, obviously. So it's negotiating. Here, negotiating is quite the threshold to determine that to qualify someone as a commercial agent is quite low. You don't necessarily need this agent. Perhaps you want this agent, but you don't necessarily need this agent to proactively look for new customers. That's not necessary. It's not necessary for this agent to negotiate every detail of the contract. That's not necessary. So as soon as this agent actively intervenes in the origin of this contract, goes with an offer to a customer, for instance, even if this offer has been completely pre-written by the principal, this person, this legal entity, will likely be an agent and not some service provider without being an agent. The only exception is pure promotion. If your self-employed collaborator does little more than advertising your brand, does little more than distributing flyers, for instance, or perhaps passing out your business card at networking events without actually intervening in real deals, specific deals, then they may not be a commercial agent. But again, certainly in Belgium, and as I understand in other countries as well, the threshold to talk about commercial agency is quite low. Another element here, most commercial agents deal with the sale of products, of goods or services. But also, strictly speaking, purchasers being sourcing suppliers could also be a commercial agency. For instance, you might have a commercial agent, a typical example that I had quite recently, commercial agent dealing in the one hand sourcing for suppliers of ostrich meat in Africa, and on the other hand looking for retailers to distribute this meat in the Belgian and Western European market. So sale or purchase, both are possible. Another element here, this commercial agent may or may not be authorized to conclude contracts. So it's necessary to have him negotiate, intervene in the origin, in the coming into existence of a contract. And he may be authorized to conclude, sign in name on behalf, and that's the next bullet, in name on behalf of the principal. He might have a specific mandate to sign these contracts. But you need to be explicit in your contract. Do I want to think about that? Do I need my agent to also conclude contracts, sign on my behalf, so I, as a principal, are bound by a signature? And if so, think about under what circumstances put that in the contract. Does he have the right to conclude contracts, any type of contracts, or is there sort of a maximum amount, or only in a specific market, or only a specific number of clients, or only if he uses and applies the price list you agreed with this agent, or the maximum discount that you allow him to give? Perhaps you say, well, if you apply the prices, then it's okay. However, if you give a discount above 3%, you need my prior approval. So think about that, because if you do give him a mandate, you're bound by his signature, which sometimes could be a bit annoying. So could be useful, because otherwise you need someone internal in your company to sign each time, but think about it. If you look at it, if you look at it in Belgian terms, you could describe a commercial agent as a self-employed sales representative, een handelsvertegenwoordiger, representant de commerce, because he does more or less, well, exactly the same, with that distinction that he's self-employed. That's one element, and that is to talk about commercial agency, you don't unnecessarily need your commercial agent to actively, as I mentioned, proactively look for customers. And it's also quite broadly accepted that a commercial agent doesn't necessarily visit customers. He could be established in a fixed place, have his own showroom, for instance, selling children's or other garments. So you can have your fixed location, no need to visit clients to discuss, to qualify this as commercial agent, although obviously, mostly you do want your commercial agent to actively look for new customers and new business, to visit clients, if not face-to-face, at least by email and phone or Teams or whatever. But not necessarily to talk about qualify this as commercial agency. What is necessary is that the relationship between the commercial agent, the self-employed collaborator, and the principal is durable, is lasting, that they have the intention of working exclusively or not working on a longer term. And this differentiates the commercial agent from the broker, the makelaar in Dutch, that works ad hoc on specific contract-to-contract base, rather than sort of framework agreement under which several transactions may be negotiated. So it's a durable relationship, sometimes shaky, not always exclusive, but the idea is to work together on a longer term perspective. Exclusive or not, that's the next point. You may want to decide to appoint your agent as an exclusive agent, by which I mean a dedicated territory. You may say that, well, your exclusive agent for Flanders, it's also non-exclusive for other territories, whatever you want, that's all contractual freedom, but it's something you need to think about. Do you want your agent or do you as an agent want to be exclusive? Yes or no? Which territory, under which circumstances? Do I want this exclusivity to be bound to be linked to the full duration of the contract, or do I want to segregate the two, which is possible? Say, okay, this contract is for indefinite duration, and I can terminate on these and these circumstances, but I can also revoke your exclusivity under other circumstances, also possible. Something you need to think about: do I want to give, or do I want exclusivity? Exclusivity for the territory or for a specific sector, specific number of clients, that is all possible. Conversely, do I want my agent to work exclusively for me? That's also possible. Say that this agent may not work for other principals, or the variation on the theme, not work for other principals maybe, or have other activities, but not for competing brands. So that's something you need to think about and put in your contract. If you don't, is not exclusive. A bit of terminology. Agency is sometimes a bit confusing. Difference between a state agent that works ad hoc, not a durable relationship. Of course, especially in English, advertising agencies, government agencies are not commercial agents in the sense that we're talking about today. So it's a bit of a terminology thing, but that's commercial agency, negotiating the sale or purchase of goods or services in name on behalf of the principal. That is basically it. As self-employed, again, natural person, that's one option, but also a company, a legal entity. Commercial agency and international trade, that's the topic for today. I see a lot of commercial agency contracts which are, let's say, domestic, a Belgian company or the Belgian affiliate of or daughter company of a large international group, appointing local representatives as commercial agency to work on local customers. That's one thing. Or banks, for instance, at the Fintro and so the likes, they all work with self-employed agents targeting local customers, the local market. But still, commercial agency is, or potentially could be, for you as a principal, a very interesting way of distributing your goods and services across the border to different markets for a number of reasons. One of the reasons, one of the main advantages for you as a principal is that it limits, much as distributorship contracts, it limits your risk, it limits potentially your investments. If for no other reason than the fact that most commercial agents work on commission base, there's no need to give them a minimum wage. You can work on commission or a mixture of fixed compensation and commission, meaning that if they don't sell, you don't pay them. And as they are self-employed, many of the investments, the costs that they might incur, whether it's a mobile phone or a car, or perhaps a showroom, again, what I mentioned about the fashion industry, a lot of commercial agents there. You can put the cost of these investments and the risk to some extent, you put it with the commercial agent as an incentive to do well and to invest wisely, not overinvest, and put it all in developing the market and generating turnover that you may want, that you probably want. That's one thing. Another advantage when I talk to limiting risk and investment is many agents that might already have access to the market, perhaps already distribute some competing or complementary brands, so they might be able to yield economies of scope or scale by adding to their range your own products in a way that would be much more costly if you as a company, as perhaps a small company, would be able to do. So that's another thing. Perhaps you can contact a commercial agent that already has a customer base, already has access to the market, which limits the cost of your investment, which sometimes it's very interesting for smaller companies that may not have the resources to develop that market with their own affiliate, for instance, because the cost for investment would be too high, particularly if it goes wrong. These are advantages which are similar to distributorship agreements. The main difference is, and that's a key advantage for commercial agency, is the ability to maintain control. Distributorship agreements, you have someone buys and sells, and you know that under European competition law, Belgian competition law, it's impossible to impose a fixed price. You cannot fix your price, you cannot impose your distributor. You have to resell at that price, although many suppliers want that really badly. For commercial agency, it's a bit different in the sense that especially if they're not authorized to sign on your behalf, they do come back to you and say, oh, this customer wants to buy at that price, is that okay? And then you say yes or no. You can sell to whomever you want or whoever you refuse access to your products to those companies that you don't want as customers. That's one thing. You can also fix your prices, because your contract between you as a principal and the agent, if it's a real agent, if it's really bound to your own company, falls outside of the scope of European and Belgian competition law, which means that price fixing is possible. You can impose your agent, say, okay, you can enter into contracts in my name and your behalf, but you must apply this price list. And nothing else, and nothing more, and nothing less. Nothing less being the key issue here. So that's a main advantage if that is important to you. Another element here is because of the potential advantage for international trade for commercial agency, the European Union has imposed minimal harmonization via the directive we'll be talking about later. And that directive in itself, because the law has been harmonized throughout the European Union, that is also an advantage. I don't know what this is. Also an advantage for commercial agency, because you know that the law in the different member states is more or less the same, which makes it a useful tool for small companies. For agents, for instance, I know that if I have a contract under Spanish law, for instance, I know that although I might not be fully abreast with the intrinsic details of Spanish law, I know that I have some degree of protection that I know from my own Belgian perspective. That is also perhaps one of the downsides, especially for principals, mandatory protection for the agent, and regrettably, maybe, I don't know, only minimal harmonization. There are still differences between the different member states, and some of these differences are certainly potentially quite important. Okay. Voila. The directive itself, the scope of the directive, one of the first articles of the directive, it applies to, well, self-employed intermediaries with continuing authority, this is what I talked about, to negotiate the sale or purchase of goods on behalf of another person, the principal, or to negotiate and conclude such transactions. So it's all on behalf of the name of the principal. He doesn't buy and sell in his own name, on his own behalf. and he may be allowed to conclude these transactions, but basically it's negotiating. That's enough. But, and I'll talk about that later also only limited to the sale and purchase of goods, with the exclusion of services. What does this not mean? The first exception is this. First exception is the most important, probably. An officer, a director, or a company or association is not a commercial agent, although he might negotiate deals on behalf of his own company, for which he represents. If he does so in his capacity of director or manager of the company, he is not a commercial agent. I've seen a few efforts to try to former directors to claim the protection of the commercial agency directive. This is a no-go. This does not apply to those types of agreements. What is the ratio legis of the directive? Well, the Commission was of the opinion that the differences between the different member states, because several member states already had specific rules on commercial agency, Germany and France, for instance. Other member states had, well, more jurisprudence that applying general principles to this type of contracts. But the idea was that the differences between these member states and legislations affect competition, are detrimental, and prohibit perhaps entering into contract between agents and specifically smaller principals, smaller companies, from entering into the contract, and thus indirectly limiting the access for mostly smaller companies, access to the markets of other member states because they denying, inhibiting, prohibiting access to this potentially very interesting way of distributing your products and services to another member state. So that was the general idea, to justify harmonization. As I mentioned, it's only, and that's quite important, only for the sale and purchase of goods. So if you're talking about commercial agency for services, financial services or other services, you do need to check, does the law that I choose also apply, also have the corresponding protection, yes or no, for services? And depending on whether that's a good thing or bad thing, you decide on that law or not, or you expand the focus of your contract to services. The directive focuses mainly on trying to protect the agent. That's the main emphasis. We're trying to protect the agent. There's some protection for the principal as well, but it's mainly protection of the weaker contracting party, in most cases, the agent. Focusing on the contractual terms as opposed to the pre-contractual. So the idea is not to make sure that the agent is informed of the contract, the terms of the contract that he's entering into, but to prevent the principle of putting in this contract clauses that are, well, would be unfair vis-a-vis the agent. Try to balance the contractual terms between the justified, or the justified for the agent to want, or justified for the principal to want. So it's a balancing act, but a balancing act enforced upon parties through mostly mandatory legislation. Another point that's quite important, it's minimal harmonization. I already mentioned that. So and this is the next slide, the directive talks about some of the key issues of what you would expect in a contract, in an agency contract, commercial agency contract, but not everything. Not everything is set out, and not everything is certainly set out in detail. And for other aspects, the directive does suggest, I would almost say, suggest some things, but leaves some freedom, more or less freedom, to the member states, a freedom of choice in a number of some quite essential matters that you'll see on the slide. So the first thing is that it only applies to the sale of goods. So the member states are, and Ireland, for instance, are free not to transpose this directive to services, only goods. Some have, but not mandatory. It's limited, as I mentioned, to a number of key aspects, termination being, and indemnity for goodwill and compensation being the most important issues, the issues, well, that are mostly litigated about, obviously. This in combination often with restraint of trade clauses. It does not talk about the pre-contractual phase, about the authority that the agent may or not have, about the credere, about the grounds for immediate termination. It does talk about that. You can terminate in case of substantial breach, for instance. It does say that, but it doesn't specify what should be determined as a material breach, for instance. It leaves that up to the member states or the courts to decide on whether or not this is an immediate material breach, and whether or not in your contract you are free to determine what is a material breach, yes or no. So another things that are not put in this directive, sometimes governed by applicable law, for instance, other regulations, EU regulations, but for the rest it's left up to the member states and or the contracting parties to determine what they want. Linked to that, it's minimal harmonization also in the sense that it leaves, as I mentioned, freedom of choice in a number of non-negligible cases, matters, such as, for instance, the length of the notice period. You have a minimum, but member states are allowed to go further to give more protection to make this notice period longer if they should so want. And there are a number of other differences and other freedom of choice possibilities that the member states have. For instance, the amount of conversations, we'll talk about that, the role of equity, what is equitable or not, that's also a very interesting point of discussion. In the case of indirect commissions and so on and so forth. So a bit of freedom for a lot of freedom from the member states, which implies that for some matters, but again, and I'll emphasize that and again, the law you choose to be applicable to your contract does indeed matter, even if this law is one of the EU member states. This is a few examples. To my knowledge, most member states have transposed, not all in time. Belgium was obviously too late, but more or less correctly. If I look at the case law from the Court of Justice, there are a few things that are under debate, but I have the impression that mostly it was transposed more or less correctly. These are a few examples, but only a few. I think, again, to my knowledge, every member state has transposed the directive, either, as you will see on the slide, in a specific act, such as Luxembourg, or has integrated it in, for instance, the specific, the Handelsgesetzbuch, for instance, Code de Commerce in France, so the Code of Economic Law, as in Belgium, or again, a specific act. Belgium, again, too late in '95, it's a bit too late, but have transposed more or less correctly. There's one exception, we'll talk about that, one exception. Currently, it's been integrated in the Code of Economic Law in Book 10 without any changes. So the initial act of 95, was integrated in the Code of Economic Law without any material changes whatsoever. So the case law before still remains valid. A side note here, as I mentioned, the directive does not talk about the pre-contractual phase, only about the terms of the contract itself. The contractual phase is left to the member states. Such a thing as dwaling and dol, and that's one of the concepts that will stay applicable. Specific here for Belgium, in Title 2, Book 10 of the Code of Economic Law, previously the Act of 2005, the Pre-Contractual Act, Pre-Contractual Information Act of 2005, scope of which was, well, the idea was to focus on franchising. If I looked at preparatory works, we talk about franchising, mostly quick and problems there. But the idea of the legislature was to put it much broader. It's defined not as franchising, but applicable to commercial partnership contracts and commercial formulas. So it's one party, one company, one self-employed person that receives the right to use a commercial formula granted to him. That right is granted to him by another company. So that's the definition. Initially, a bit of discussion: can it apply to commercial agency? Personally, I was of the opinion, I'm still of the opinion that that was not. If you look at the definition, it could not apply to commercial agency. However, the legislation has changed, so now we can all agree that it potentially applies also this act to commercial agency, with the only clear exception being banking and insurance. That's expressly excluded. But well, as that is excluded, I think you can infer that commercial agency contracts other than banking and finance are at least potentially falling under the scope of this specific legislation. There's a bit of case law on this also. Again, most case law talks about franchising as we know it. There's a bit of case law on commercial agency as well, that the act applies, I mean. But the criteria are a bit vague. There's one case that I think about, which is on the naming statement, the Court of Commerce of Ghent of 2019, 18, stating that, well, this act, Pre-Contractual Information Act, applies to commercial agency, but the criteria are a bit vague. If I look at this case, the court ruled that because that commercial agent has a business card with the name of the principal, because he used the email address from the principal, because he was given a lot of brochures and other commercial information to help him sell the product, that was, according to the court in Ghent, enough to qualify him as this relationship, not only as commercial agency, because that qualification was not under debate, but also as commercial partnership contract within the meaning of Title II, as opposed to Title I of Book 10 of the Code Economic Law. So that was quite a bit unexpected, and also a bit problematic because the criteria are a bit vague. And as I mentioned, email address, business card, etc., commercial information brochures given by the principal. Many principals have these things, so you could fear that many of your commercial agents might fall on the scope of this specific of Title II as well. Why is that a problem? It's not necessarily a problem. What does the act mean? That prior to entering into this contract, before the contract can come into force, there's a month pre-contractual cooling off period, if you like. You have to give the draft agreement, final draft agreement, separate document with the key clauses, another document or with the key information about you as a principal, as a franchisor, about your accounting, etc. And then 1 month that the franchisee has to think about it. He's not obliged to think about it. He has 1 month to talk to his accountant and his lawyer. He's not obliged to do so, but he has a month to do so. And the problem here is that if this cooling off period is not adhered to, the contract will be null and could be declared null and void by the party that receives the right to commercial formula. So that's potentially problematic and an easy escape for the agent in this case to get out of his contract or invoke the nullity of specific clauses. Typically would be the non-compete clauses. And these specific act, these specific rules are at least mandatory, and I think overriding mandatory provisions by the police, so you can't opt out even if you would like to. From an international point of view, this act is Belgium. It's not a transposition of any European directive. It's a Belgium initiative. But on the other hand, you do see in many countries within Europe and outside pre-contractual protection or mandatory acts protecting franchisees with a cooling off period, which varies from time to time. If I look at some of these legislations, for instance, France, La Dubin, which is a good example of in the 80s, if I look at the text, I don't think it applies to commercial agency, but when I talk to some of my colleagues in France, they say, oh, some case law may qualify this commercial agency as falling under La Dubin and making this cooling off period mandatory. So it's something to think about when you're drafting. The directive itself, the scope, as I mentioned, this is the definition, only applicable to the sale or purchase, again, or purchase of goods, not services. Member states, and that's case law of the Court of Justice, are allowed to expand the scope of this protection, that transposition of the directive to services or to some services or services with the exclusion of some services. Belgium has gone all the way, if you'd like. It's applicable to goods and services. Initially, there was an exception made for financial services, but that exception was revoked and also declared unacceptable by the Belgian Supreme Court. So now it's goods and services, including any financial services. Many other member states have done more or less the same. France, Germany, for instance, and our main trading partners, goods and services. But in some cases, with an exception of some financial services, France, for instance, and Netherlands have excluded all financial services. Other member states, and for the sake of convenience, I will still look at UK as a member state, have limited the transposition to goods. Ireland's probably the best example. They initiated an act saying, well, look at that directive, it's now a national law, full stop. And then they forgot that there were choices that had to be made, and then they had in 1979, I think, 97, I think, a different act to amend. Anyway, but some countries, again, only goods, and this is something you need to think about. If the scope of your commercial agency is services, or at least includes services, you need to think about, if we choose for the laws of Ireland, for instance, what are the consequences thereof? Might be a good idea to do so, might not be a good idea, depending on your perspective. I promised you a few clauses for your inspiration. This is one of them. Just a clause, something you could use. The principle appoints the agent, but except as I have emphasized here, non-exclusive. Exclusive commercial agency is possible, non-exclusive is possible. It's what you want to put in the contract. But do think about it. If you appoint someone as exclusive agent, well, every transaction that is concluded in his or her market will yield commissions for that agent, regardless of whether that agent was actively involved in that deal. So exclusive or non-exclusive, or something in between, exclusive again, with the exception of these and these key accounts, or non-exclusive with the exception of these customers that you already had, for which you will remain as exclusive commercial agent. It's whatever you put in the contract, but at least again, think about what you want. And you can also put, well, you think about it, is this agent allowed to solicit orders for the products outside his own territory? Yes or no. Often the answer is no, we don't want that. Rights and obligations. Here again, the directive does not go into immense detail. What you read on the slide, well, is quite general, and I sincerely hope that doesn't shock you. It's a good faith variation on that theme. Both the agent and the principal have to act in good faith, make proper efforts to negotiate and conclude transactions. So make an effort, not simply rest on his heels or her laurels, and provide information that is necessary either for the principal or the agent to make the collaboration work as it should work, to put it in those terms. Not quite what the directive puts it, but more or less the idea. And all of this is mandatory, rights and obligations, and the same holds true as a sort of, again, a sneak preview for most of what we find in the directive, and then the national transposition legislation. Most of that will be mandatory, or will be mandatory to the benefit of the agent as opposed to the principal, or for both parties. So it's mostly the agent who's being protected, again, as a weaker contracting party in a mandatory way. A clause, again, for your convenience, doesn't really say much. Use a best endeavor to promote the market, and market the product in the territory, seek orders, or actively look for new customers. And again, need to think about, is this agent entitled to enter into contracts? Yes or no. To bind the principal? Yes or no. And if yes, under which circumstances? You could say, well, you can enter into contracts, but only for that amount, or only if it applies the price list. That's Annex 1, and the general terms and conditions of sales. That's Annex 2. So that's all possible. A lot of freedom on that level. Remuneration. Of course, most agents want to be remunerated. How? That's a lot of freedom there. So you're free to decide to negotiate how you will remunerate this commercial agent. Is it a fixed amount each month? Is it, or for the first X months before, as soon as he gets his act together? Or is it commissions, or is it a mixture of the two? Or is it reimbursement of costs? That's also an option. Combination of that all. The amount of the commission is also freely negotiable. So it could vary. You could say, okay, for that range of products, it's X%. For those customers, it's Y%. So you can vary, put in an annex, whatever you want. A lot of freedom there. So it's what you negotiate. We could say it's for the first year, it's X%, and it goes down, it goes up, whatever. That's all freedom. If you say nothing in the contracts, normally you put something in the contract. It's very often that's the one thing people do put in the contract. If you fail to put something in the contract, then the directive says it's what's customary, and if no such custom exists, it's what's reasonable. But if you don't want that, You don't want the court to decide for in your place what is reasonable or what is customary. You don't want that, but it's a default that exists. So freedom, a few exceptions. I will not go into that in great detail. The agent will have a mandatory right to commissions. What commissions? The one you agreed upon. For contracts concluded during the agreement, in some cases after the end of the agreement, that's mandatory. When such commissions are due, that is to extent mandatory. When you can, to what extent you can include in your contract that the right to commissions is extinguished, in which cases that is possible, that's mandatory. And how it's calculated, that's an exception, not completely mandatory. But all of that is in the directive and hence in the transposition legislation. Also Belgium. So again, mostly mandatory, protection of the agent, few exceptions, but you need to, again, check per member state, if that's important, whether specific clause which may not be mandatory under the directive may still be mandatory under the legislation of the member state. Specific for Belgium is, and that's not in the directive, it's put in the Belgian Act, that a unilateral change of the remuneration of the commissions, mostly commissions, is ipso facto treated as a breach of contract. There's a plus and a downside there, which means that any other change, unilateral or trying to impose a change other than remuneration, is not necessarily a breach. That's possible, but it's clear that if you try to unilaterally change your commissions, that is equal to a breach or a termination of the contract, and will mean that you as a principal will be may be forced to pay certain compensations. We'll talk about that, those compensations. What is the solution? Because obviously, initially the remuneration you determine, the commissions you agree upon may be completely reasonable, but after 5, 10, 20 years, well, those you may think that those percentages are overcompensating. And you may feel that, well, it doesn't really work anymore, and all I do is invest in his market. Doesn't have his act together. That's possible. How to deal with that? Well, sometimes one option is if you try unilaterally to enter in negotiations, and if the negotiations fail, you need to terminate. A lot of banks do that from time to time. They update their commissions to bring it more into sync with the reality of the market. And for those agents who do not go along with that, they are forced to terminate, to give notice. Another approach could be not to agree on remuneration in the long run, by which I mean that you set for the first year, for this year, each year or each quarter or each 10 years, or I don't know, you agree on the remuneration, and then you say, well, afterwards we'll agree on new terms. So this is a clause that you could use. Say, well, commission equal to X%, but again, you put in an annex with all types of variations. Lengthy annexes I sometimes see, but another approach would, well, it's X%, no further questions asked. And you could say, well, Schedule A in this case, that's the commissions. It applies to the first year, the first 2 years, and afterwards we'll discuss a new commission schedule. You do that, that's completely valid. It avoids a discussion about, oh, you changed unilaterally. No, we didn't change unilaterally. There was no agreement on that. But of course, the problem there is there's no agreement on it. But what's the default? What is the default if we fail to agree on a new commission schedule? What's the fallback position? Either put it in the contract what the fallback position is, perhaps the same as in the past, or a certain minimum, or customary, and whatever the court feels is customary. So that's one approach, not completely without risk, but what is the default and is acceptable to the agent? Often no, but one potential approach. Termination, that's another thing. You may want to terminate. The basic principle is if it's entered into for an indefinite period, each party may terminate by giving notice. That is an international generally accepted principle. It applies to all types of contract, including but not limited to commercial agency contracts. What the directive confirms that principle, not really shocking, but what the directive does do is specify what that period of notice should be: 1 month per year that is commenced, with a maximum of 3. However, and that's one of the things we talked about, minimum harmonization, member states are allowed to impose a longer period of notice if they so choose, and may decide that parties may not agree on shorter periods, but I think the sentence says that may agree on longer periods of notice. Belgium has done that. It's completely possible in Belgium to say, okay, it's 1 to 6 years, 1 to 6 months per year that's commenced, but parties can agree on 6 months from the very beginning, or 1 per month for the first 10 years. It's all possible. And all permissible member states are allowed to extend that notice period if they so choose. Very few member states have done that beyond the 6 months, I mean, but no member state has done that to my knowledge. But many member states, including Belgium, has opted to extend to the 6 months. Belgium, the rule is 1 per month per year with a maximum of 6 months. Parties may not agree on shorter periods, but may agree on longer periods, as long as the period of notice to be adhered to by the agent is not shorter than that to be adhered to by the principal. France 1 to 3 months, longer is possible, but so it's more in line with the directive. The Netherlands, a bit of an oddball there. 4 months initially from the very start instead of 1 month, up to 6 months. Parties may agree on something else, but then that something else needs to be at least what the directive 1 to 3 months imposes. So a bit more freedom there, a bit of a different approach in the Netherlands. Makes a bit of sense, I think, because many agents will invest. If they do invest, well, the cost of that investment will be in the very start of the collaboration, and will perhaps no longer be that important after year 1, 2, 3, and 4. And well, at least you will see on the slide what a few member states have done, but to check in each case from each member state to member state, it can vary, and that's a good point I will come back to many often today. The choice of law, and despite of the directive which harmonizes the choice of law, Belgian law, Luxembourg law, Irish, it can matter. It can be of a financial impact. It can impact how easily you can terminate, or how difficult or how costly termination will be. This is a perfectly valid clause, which is based on the Belgian concept. So it's 1 month per year that is started, not ended, one started year, with a maximum of 6 months. But again, longer is possible, sometimes advisable, but it needs to be at least as long for the principal as it is for the agent. Termination. So we talked about the period of notice. That is the minimum to be put into contract, to be adhered to. What if parties fail to adhere to this minimum notice period? This is something that is not completely governed by the directive, the consequences thereof. One thing I mean is that whether or not a court is in a position to force parties to keep to the contract during the notice period, to enforce it in natura. The Belgian law, it's not possible. Other member states maybe, but that's left to the courts and the member states. Another thing that may or not be implied in the directive is what is the financial consequence of not respecting this period of notice, or only partially. You give 1 month, whereas it should be 2 months, 3 months, and so on. One approach, one interpretation, is that it's completely out of scope of the directive, and it's left to the member states' national law to put it in the specific law or the general civil code, for instance. Another approach is to say, well, and I agree with that approach, it is somewhat in the directive. If you look at Article 17 of the directive, Article 17 talks about, in case of termination, you need to pay, the member states need to provide either for indemnity for goodwill, klantenvergoeding, this is the Dutch version, for the client base that is established by the commercial agent, or compensation for damage. One is a German system, the other is a French system. The German system says compensation for goodwill, so clients, it's the added value, the advantages generated by the agent, not the damage suffered by the agent. But still, at the very end of that clause, it's the grant of such an indemnity for advantages shall not prevent the commercial agent from seeking damages. Which damages? If I look at that in the directive, well, I think it should be in the perhaps not exclusively, in the first place, damages suffered by an abrupt termination, because the directive does not talk about what happens if this minimum period of notice is not respected. So that's damages. But what damages, that's left to the member states. Is it fixed? Is it for the courts to decide that the actual damages suffered? That's left to the member states. And number 3, the French system says that in case of termination, the commercial agent shall be entitled to compensation for damages he suffered. One of these damages, the damage he suffers, obviously as a result of the abrupt termination. It's not just the loss of commissions, but the fact that perhaps he has employees that he must terminate, must dismiss because of indirect causal relationship to the end of the collaboration with the principal. That's also part of his damage. It's not limited to the loss of commissions sensu stricto. So it's something in the directive, but it leaves, and that's the point I'm trying to make, leaves a lot of freedom to the member states to implement. How did Belgium go about this? A fixed approach. I put it here in Dutch, but it says that the compensation in lieu of notice is the compensation that the agent would have made during this period of notice. So you look at the last 12 years, the average he made, I don't know, 5,000 a month. It's then, in case of 6 months, it's 6 times 5,000 euros that he can compensate as an indemnity in lieu of notice. So it's fixed. In the Belgian system, there's no possibility for the court to decrease or increase. For instance, well, okay, you would terminate abruptly, but after 2 months or 2 weeks, you had another principal. So in fact, your real damages are negligible. Still, it's fixed. No way for the court to adjust above, increase or decrease. There's an exception here. We'll talk about that later. Other member states, and again, this is another example of how the choice of law does have an impact, even within the European Union. In other countries, sometimes it's fixed, but the courts are allowed to moderate or increase the real damage. The Netherlands is a good example. Also in Luxembourg, the courts have it's a sort of it's more of a rule of thumb. As a rule, it's the amount he would have made looking back, an average, but you can increase or decrease given the circumstances. And of course, in France, it's the compensation of actual damages suffered. So as long as you prove that it's actual damage suffered, you can claim under French law, for instance. Although there also the courts de facto look at a more fixed approach to years of average compensation. That's something we'll talk about later as well. And then we come to what I think is the most, at least interesting and litigation-wise, the most important issue: indemnity for goodwill, the indemnity for the client base that the agent has generated and which will continue to yield benefits for the principal after termination. Because the idea is that this commercial agent works for someone else and is selling someone else's brand. So if you cut out the middleman, the intermediary, often in all likeliness, not always, often in all likeliness, the customers will continue to sell, buy from the principal and not from the agent, even if this agent shortly after termination now also represents other brands, for instance. So that's the idea, that good generated by the agent is linked to the brand of the principal, the agent's option. That's the goodwill that imposes on states to provide for either one of the two. So in an indemnity, that's one, the German option, indemnity for the benefits, the advantage of the client base that the principal will retain after the end of the termination of the agreement for whatever reason. That's one. Or compensation, damages, the loss of commissions that the agent will suffer because of the termination of the agreement. So that's loss of commissions, and also, as I mentioned, these commissions are used to pay his own staff, to pay the rent of his showroom, etc. So the damage is suffered because of termination. Both the idea is to prevent abrupt termination, prevent opportunistic termination, and to make sure that this agent can reap the benefits, reap the fruits of his own labor, the client base he has established for the principal. There's a bit of an overlap there. Obviously, the loss of the advantages for the principal after termination are also the loss the agent to some extent, and the loss is also linked to the benefits that will continue to go to the principal after termination. The two overlap, but there is, from a conceptual point of view, a substantial difference, and more importantly, well, more importantly, the amount. If you look at the German system, its benefits, the advantages, but maximum 1 year average remuneration over the last few, calculated over the last 5 years, whereas under the French system, French Cour de Cassation has accepted that as a rule, there are exceptions, but as a rule, the agent may claim 2 years of remuneration, average remuneration over the last year, which is obviously a lot more than 1 year, about double. So there is a very important difference and a very important thing to consider whether you choose, for example, Belgian law, 1 year, German law, or French law, as a rule, 2 years in case of some cases of termination. We'll talk about the exceptions as well. But again, it's mandatory. The directive is mandatory. This particular clause is mandatory, which means that as long as this agent is operating in the European Union, you cannot opt out this protective system by choosing for Japanese law or what have you not. It's mandatory. It's overriding mandatory. You cannot opt out. For me, the Court of Justice hasn't really confirmed that yet, but implicitly, I think, if this agent is established outside of the European Union, it's not mandatory, which I mean, if you have an agent working in the US, you can still choose for Belgian law, Spanish law, Swedish law, whatever, without introducing this specific protection. So you can, well, opt out of the indemnity system, say, well, no indemnity for goodwill, because I think that it's not mandatory outside of the European context. But in the European context, it is mandatory, even if the principle is non-European, as long as this agent is established within the European Union. What about Belgium? Belgium has very clearly and decisively chosen for the German system. So it's an indemnity for goodwill. What they have failed, when I talk about transposition, has been more or less accurate. This has not been accurate. The German system says, Handelsgesetzbuch says, indemnity for goodwill if established new business extension, it's more generated more business that will continue to yield benefits for the principal after termination, and it adds third criteria, necessary condition, that this compensation, if and so far this compensation is equitable. German case law says that, well, you can go, as long as you say below the 1 year, it can go down or up. If it's not equitable, for instance, well, it's not equitable because, well, the agent is going to retire anyway, or he has managed to transfer a lot of that goodwill to his new principal, for instance. You can go down, but you can also go up. That condition of being equitable has not been transposed to Belgian law, which is a mistake the Belgian legislator made. What they have introduced is so a pure indemnity for goodwill linked to its pure way, the benefits for the principal, whether it's equitable or not, the compensation, I mean, the benefits for the principal. If it talks about new customers and or increase of volume of business with existing customers. So it's one of the two or both that is taken into consideration. Of course, one way of mitigating the damage you may need to pay is to say in advance, if there is an existing client base, to determine what is that existing client base, because the agent will only be entitled to compensation for customer base generated by the agent's activities. So if you say in advance, well, this is the existing customer base, so it's also the net difference that will be taken into consideration when we are determining whether or not the agent is entitled to indemnity, and if so, the amount of said indemnity. So that's one thing, one approach to mitigate the potential claim for the agent. The Belgian law also says, and that's not in the directive, that the principal peut derive substantial benefits from this customer base. Some case law says, well, it can, so whether or not the principal continues to reap the benefits, that's immaterial. That's not really true. I think it's a sort of nuanced approach. The Belgian Court of Cassation says, well, the indemnity for goodwill is payable if the client base is reasonably, we talk about reasonable expectations. You can reasonably assume that that customer base or a substantial part thereof will stay with the principal. And I think that's two ways of saying the same thing. The benefits that you need to compensate are the potential for this customer base, because customers aren't slaves. They may leave at any time sometimes. So it is in any case a potential, reasonable expectations. That's the benefits that you need to compensate. So it's sort of at the end of the agreement, you make an educated guess. Is that customer base, maybe reasonably assume that it will stay with the principal? How faithful to the brand is it? Have they gone bankrupt? Obviously, that's things we need to talk about. Sometimes it's clear, sometimes not so clear. One case may be that the agent is in a position to take a lot of clients with him to the new principal. Well, that's one thing, consideration to say, well, no indemnity for goodwill, or the amount of the indemnity for goodwill needs to be moderated, not 1 year, but it's half year, 3 months, because it's, again, maximum 1 year. It's maximum. Every agent will claim, oh, I need 1 year. The courts do go lower depending on the circumstances. There is an additional, there's indemnity for goodwill, a lot of debate about that, still a lot of litigation about that. And in addition there too, the additional compensation for actual damages, which is the second example where the Belgian legislator went wrong, because it's completely unclear what this additional compensation was intended to be. The Court of Justice has ruled, meanwhile, that it's not allowed for a member state to say, okay, it's indemnity for goodwill, but in addition, you can claim whatever damages, loss of commissions. That's to combine the two, that's not possible. So an additional compensation must be other damages, such as, for instance, severance payment you have to give to staff, you have to dismiss, or investments you made, a lease contract you made that is now, because of the termination, because of the lost cost. The Belgian case law has confirmed that. Well, it's all other damages other than the loss of customers, a lot of loss of commissions, subject to a causal link between the damages, obviously, and the termination. What does that mean? More no case law about that. Fairly recently, the Supreme Court has confirmed that it's only costs, it's not only costs and investment made by the agent under a contractual obligation to do so, or recommendations of the principal, not costs made voluntarily and at its own initiative. So one example could be your agent has a showroom in Antwerp, and against your recommendation as a principal opens a new showroom in Hasselt, for instance. That cost made again freely against recommendation of the principal will not be compensatable under the Article 19 of the Belgian Act. Other member states, France obviously has chosen for the French system, no big shocker there. Many other countries, most of our important trading partners, have chosen for the German system with the equitable, the Billigkeit incorporated in their national legislation. Exception there being, again, UK, a bit of hybrid system, choosing for compensation the French system, strangely, but less strangely, the House of Lords has decided not to apply the French principles to the French the French system, and to say, well, it's not the damages that loss that is really important, but we look at the market value of the business lost in the given circumstance. So we do not necessarily impose the 2 years that the French jurisprudence, French courts impose as a rule. House of Lords said, no, we don't do that. We have a different approach. We interpret the same text in a different way. And UK also allows for a choice possible for the indemnity as opposed to compensation. But the default, again, is the French system of compensation, again, applied differently than in France. Why not? Some exceptions, indemnity for goodwill you have, again, if you established additional customers or extended the customer base or new business, a number of circumstances such indemnity is not payable if, to put it in these terms, the principal is terminated because of the default of the agent, a material breach, or the agent terminates, he gives notice and switches perhaps to another principal, unless such termination is justifiable circumstances. For instance, is age. The commercial agent is 70 and wants to retire, for instance. That would be a grounds to give notice period has to be adhered to, but also still claim indemnity for goodwill if the other criteria are met. So in this sense, the indemnity for goodwill is for some commercial agents, natural persons mostly, sort of additional pension, if you would like. And of course, also if the agent assigns the contract and the right, including the potential claim for indemnity for goodwill to another agent with the approval of the principal. Important here, specifically in the Belgian context, is a lot of formalities that have to be met. You have to communicate, that's in the directive, to the principal, I want this indemnity within a year after termination. But also, and that's specifically for the Belgian context, you have to claim it, you have to bring the proceedings, you have to file suit, bring this case before the relevant court within 1 year after termination. 1 year and 1 day, too late, you cannot claim anything anymore. Also, and that's also very important and a killer sometimes, if you want to terminate because of material breach, you have to do so within 7 days after you know about the material breach and established that this breach is indeed material. The case law is a bit flexible on that, but it's 7 work days as soon as you know about the material breach and have established there's no doubt that this material breach is a fact. And in addition, 7 working days after you terminate under this because of this material breach, you have to motivate why you have terminated, and you have to put every motivation, every reason in there. You cannot afterwards invoke additional reasons justify after the fact, which implies obviously before you decide to shoot, you need to be damn sure that your case is strong enough. But that's the specific Belgium context, and now I'm trying to switch to the next slide, and I can't. Restraint of trade clause. So we talked about, I think we talked about, indemnity for goodwill, talked about that. Restraint of trade clauses, as I said, it's perfectly possible to put in your contract, you as a commercial agent will solely represent me, will solely represent my brands, my products. It's not mandatory. You can, sometimes it's a better idea to choose an agent that also represents complementary products or even competing products. You can do so. More sensitive is after the termination of the agreement. You may want to put in your contract a clause prohibiting, de facto prohibiting your agent from transferring your goodwill, transferring your customers to a new principal, putting in the contract you are not allowed to compete to sell competing brands, or even be active in that specific market. Why is that in the directive? Because, as I mentioned, one of the key advantages, potential advantages of commercial agency is that it falls outside of the scope of competition law, with the limitations there on non-compete clauses inherent in competition law. So this is why we need to put something specific in the directive and then in the national legislation. So this is why it's in the directive. The restraint of trade clause and non-compete clause after termination, again after the end of the contract, could be valid, but only, as you read on the slide, only if and to the extent that it is concluded in writing. So an implicit is not permissible. Some case law does accept an implicit non-compete clause during the agreement, but afterwards it has to be in writing. It must be limited to the area, the territory of or the group of customers entrusted to the agent. You say, okay, you are exclusive or not in this territory or for this group of customers. The non-compete, the restraint of trade clause, also has to be limited to that territory. It has to be limited to goods or services. The directive talks about only of goods, but it's also, we'll see about also services covered by the agency, so not broader, not if the agent only represents a specific product range, only competing products, even if you as a principal have a broader scope of products for other markets, B2C, B2B. So it has to be limited to that. And a maximum of 2 years, that's quite a long time, 2 years after the end of the agreement. Can you go further? This is mandatory. The member states are allowed to impose further restrictions. So not be more lenient, but are allowed to put further restrictions. And a lot of member states have done just that. including Belgium, limiting, that's the most significant additional restriction. The restraint of trade clause is valid, but it's limited 6 months after the end of the contract, which is not that long. Sometimes for some sectors 6 months is enough. For some products it's quite short. So that's something you need to keep in mind. The sanction, also specifically Belgium, the sanction, forfeiture sanction, is limited to 1 year of average commissions as a penalty. The sanction is, because the directive doesn't talk about that, it's mandatory, it's prohibited, but what is the sanction? Sanction in Belgium is quite clear. A clause that goes beyond what is permissible is null and void. As you see, some other states, member states have variation. Luxembourg is 12 months. Austria said, well, restraint of trade clause are simply prohibited. So it depends, and member states are allowed to be more strict, as I mentioned. This is a clause based on the Belgian principle of 6 months, but again, other member states might accept longer restraint of trade clauses. Of course, your opposing party or agent also would need to accept this clause. The creditor, very briefly, as a rule, you as a commercial agent is, well, you have the risk of the client not paying, in the sense that you can put in your contract, you only get paid as soon as the customer pays. You could put it that. To that extent, well, you could be liable between brackets. But if the client goes bankrupt, fails to pay his invoices, that's the problem for the principal. You can, however, commit to more extensively, commit part of your financials to the solvency of the customer to convince the principal to go ahead with this transaction. But to what extent that is possible is very much limited in the Belgian law. And that's the next slide. A lot of other member states have also either prohibited it or limited the possibility of putting part of the insolvency risk for the customer with the agent. The directive is neutral on that. It says nothing about the creditor. It doesn't exclude it either. So member states are free to do their own thing. Which leads me to I think the last point, but not the least important thing, namely international private law. Talking about, okay, we have the contract, we have the commercial terms. This is what most people find more interesting. We have the legal clauses. This is only interesting to the lawyers. And then we have, okay, what if this goes wrong? What law is applicable, assuming that it goes wrong, and to what court should we address any claim? That's something unpleasant sometimes, because, well, you think that everything will go well, but something you do need to think about. Choice of law, you can choose for, and I would advise, especially principals, to expressly choose one form and to think about what form you want. Most principals obviously choose for their own forum, whether it's in Germany, Belgium, France, Spain, for their own courts that they know, and that want to centralize all their litigation in one court. That's an acceptable reason. That's possible. So a choice of law, a choice of forum is permissible under the regulation. However, it's interpreted restrictively. So a clause in your general terms and conditions on your website, I don't know, you need to put it in your contract and expressly say, well, everything related to this commercial agency contract, okay, we go to the court of Hamburg, I don't know. If there's no choice of forum, the European rules will apply. As a rule, principle, the masala of the defendant, which will be most often the principal, or the place of the performance of the services will be most often the territory of the agent. Because if I look for case law, agency is considered services. So performance of said services, the mediation, negotiating of transactions, if it's in Belgium, the commercial agent could bring his claim not in Madrid, for instance, against the principal, but in his own territory in Belgium, for instance. So this is a reason why it's advisable as a principle to put something different in the clauses to avoid that you have to go litigate in the territory of your former agent. The applicable law, and as I mentioned a few times, the choice of law does matter. Belgian versus French law, for instance, indemnity for goodwill, 2 years as a rule, maximum 1 year. There's a difference that we can all understand there. So we do need to think about that. Choice of law is possible, it could be implicit also. I would obviously recommend an express choice of law, the last clause of your contract, whatever, but think about it and choose expressly for said or said law. There are exceptions. The choice is free, a few exceptions. The last is irrelevant, public policy. Why is that irrelevant? The Commercial Agency Act, at least in Belgium, is not considered to be public policy, so it's not that mandatory that it has to be applied regardless of the choice of law. One exception is sometimes relevant, namely the Rome I regulation allows, imposes on the national court to apply its own law if that's law, if to the extent that law is an overriding mandatory provision, and allows the court to apply foreign law if to the extent of overriding mandatory provision, to set aside the choice of law made by parties. So it's the court must apply or may apply. May is not that important in the sense that I have no knowledge of there's only very limited case law applying the Commercial Agency Act of another member state and setting aside the choice of law made for the domestic law, for instance. Very exceptional, potentially possible, very exceptional, which again emphasizes the relevancy of the choice of forum. The court that must apply the Lex 40, perhaps not that important anymore, by which I mean, initially it was accepted that the Belgian Commercial Agency Act was of overriding mandatory provision, and that the Belgian court must, if they deem themselves to have jurisdiction, must apply the mandatory provisions of this Commercial Agency Act and set aside, as a rule, the choice for, I don't know, Spanish law, for instance. However, under the case law of the Court of Justice, that is no longer possible. And I think even that's UNAMAR, I'll talk about that. But even if I look at this regarding UNAMAR, if I look at the last version of Article 9 of the Rome I regulation, as opposed to the Rome I convention that applied to older contracts, overriding mandatory provision is so crucial, etc., that I think that none of these considerations, provisions of the Commercial Agency Act fall under the definition, the current definition of overriding mandatory provisions. So, but that's a bit under debate, but that's, well, my opinion. You have whether you want it or not. Model Belgian Act, that's for the sake of completeness. Belgian international private law states that if the agent has its main office in Belgium, then the Belgian Act applies and the Belgian courts have jurisdiction. Of course, that is only assuming that these higher European rules do not apply. So it could be in a contract between a Belgian agent and a US principal, for instance. That's still relevant. But I think that this also means that the Belgian Commercial Agency Act is self-limiting, by which I mean that it's only mandatory for an agent with his main office in Belgium. So that if, for instance, the other way around, you're a Belgian principal and you conclude a contract with a commercial agent in the United States, you opt for Belgian law, then I think that the mandatory Belgian Commercial Agency Act does not apply. That if you set in Belgian law, then the Belgian general rules that the civil code applies and not the specific Belgian Commercial Agency Act, unless you expressly say including the Belgian Commercial Agency Act. So it need to be expressed, but that's a downside. As an agent, you can't just try to put it in the Belgian Act. You have to put very expressly that this specific act applies to the contract. Not entirely case law is still out on that, but I think that's a very defendable position. There's a model clause you could use with the express choice for the Commercial Agency Act, or you could also say excluding the provisions of this act, depending on whether that's acceptable for your contracting party. And you can choose, obviously, Antwerp is also always a nice place to litigate. The last point, I realize that I have very little time left, arbitration. In the international context, arbitration could be an extremely valid option, governed by the New York Convention of 58. One of the questions that we had was, if you bring litigation before the courts in Belgium. Such contract includes an arbitration clause. The court must decide, well, do I set this arbitration clause aside, or do I declare myself to have jurisdiction? And if that choice is that based on my own law as a Belgian court, or the choice or the law chosen by parties in the contract, which may be Spanish law or whatever. The Belgian courts, as in 2011, said, well, it's Belgian law. The Belgian court must decide this based on its own law, and that's implying that no arbitration is for international commercial agency contract is possible unless such an agent does not have his main offices in Belgium, but in Spain, for instance, even if he also operates in Belgium or in the Netherlands and governs has a Benelux, or the arbitrators must apply Belgian law, parties have chosen Belgian law, or parties have chosen for a law that offers equivalent protection. And it's the last thing, the equivalent protection, that I read that brings me to the Unamar case of the Court of Justice. Court of Justice saying that, well, you cannot, as a Belgian or national court, you cannot just simply set aside a choice for the law of an other member state that has, again, transposed the European directive. It's assumed to have, it must be assumed to have equivalent protection, which, well, makes that you can disregard it as a overriding mandatory provision, or disregard it based on arbitration considerations. You can only do so if you as a court rule that in the course of transposition, the legislator of the state held it of crucial importance to grant the commercial agent protection beyond that of provided for by the directive. Belgian case law has meanwhile established that the Belgian Commercial Agency Act this is not the case for the Belgian Commercial Agency Act. The extension to services, for instance, I don't think the Belgian legislature thought about that. It's really crucial. So if you choose for another law, it's deemed to be equivalent protection. Even if, for instance, the chosen law, Spanish or whatever, gives less protection, for instance, a smaller, shorter period of notice, for instance. That in itself is not enough to disregard the choice for Spanish law in my example. The only doubtful thing is, what about if you choose for a national law, member state law, that has not extended that protection from the directive to to services or some services? Personally, I think, the case law is still not established on that, but personally, I think that even in those cases, the choice for the other law will not be disregarded if it's within the European Union. But it's still, there's doubt about that, but I think that's the only issue we can doubt about. So the solution there is, if you choose for the courts of another member state, then it will never come to the Belgian court. So the Belgian court will be no position to impose Belgian law. So it also means that choosing for arbitration in these cases is could be a bit of an issue, because then, well, you might say, well, I still have jurisdiction, I will disregard the arbitration clause in itself. At least you could argue that, because some authors have said that after Unamar, well, the initial case law of 2011 does no longer apply. I don't agree with that. That's not what Unamar says. It only applies to choices for other European law, European Union, not beyond that. But I do believe that given the last Rome I regulation, as opposed to the Rome Convention on Applicable Law, with a more strict definition of provisions of overriding mandatory provisions being so strict, that it becomes very difficult to say that the Belgian Commercial Agency Act is of so crucially important that falls under that definition. And if that reasoning is followed, then there's no grounds to disregard the choice of another law, or to declare a case non-arbitratable simply because parties have not chosen for Belgian law, or even the law of another European state. But still, case law is not established on that. And that's the last slide. I've gone a bit over time, apologies. This is something I just stole from the Sepani website. That's the idea. You can just download or copy paste the clauses, but of course many variations are possible. ICC is obviously also perfectly valid option for arbitration. Which leads me to the end of my presentation. So if you have, voila, if you have any questions, I don't even know if that's possible with this forum. Maybe not. So if so, I will bid you a very nice, very pleasant day. If you have any questions, email me, call me. I will try to get back to you as soon as possible. And again, as I mentioned at the beginning, each participant will receive a copy of the presentation in the due course of time. And for those who need it, confirmation of that they participated, if they need it for the bar or collect points for the EBA, for instance. I think that concludes. That's all for me today. Again, have a nice day. Bye-bye.